Thank you so much, ma'am. Now, I would like to request Advocate Vrinda Gruber to share her standpoint on UCC.
Thank you. Thank you, Zoya, for setting the context, both historically, politically, for us. I will speak more to some specifics here because I think the context has been said very eloquently for all of us by Zoya. Some of the details I may depart from what has been said. So we know that today there is a uniform civil code applicable in the state of Uttarakhand. It was notified, the law was notified in March 2024 and the rules were notified in January 2025. So the law became operational from January 2025. Now, does the state have legal competence to make a common civil code for people who are of Uttarakhandi origin? I don't think that's a legal point that we are going to succeed on, and that's not really one that many are taking even to the court. It is correct that they have exempted the scheduled tribes within Uttarakhand from the purview of the UK UCC. It is also true, as Zoya pointed out, that the original imagination in the constitution was, and which the BJP has been advocating for a while now, including in their manifesto, that this is somehow going to bring about national unity. And I'm not very sure how laws bring about national unity. This is a country more complicated than most. And that is the main concern that had been voiced repeatedly. Over the years, she's absolutely right, Zoya, when she says it is actually seen that why should, in this instance, the Muslim community be allowed certain forms of exercise of patriarchal privilege, misogyny, and others are not. So it seems to be a competition between communities of you. If you are having, if you can enjoy certain patriarchal privileges, why should I not get the same? And this law actually is directed very much in that vein. The third aspect here being about, and now of course it's about women. Most of the things that this government is doing for the last 10, 11 years now is about that this is good for women. And many governments, not just the central government. I think if we look into this, it's a very long act. It has 392 sections and it has a very heavy set of rules and forms. It's a very difficult read to go through. It's quite complicated the way they've drafted it. And the question that one asks oneself, since one of the ways in which it has been peddled for the general public, is that this is good for women. We are making sure that women across communities have a better status, have equal rights, etc. As Zoya very rightly pointed out, all personal laws have been discriminatory. Different personal laws have moved and ameliorated the situation in different ways. For instance, let's talk about the Christian community where divorce was not allowed. And it was a long campaign by the Joint Women's Program based in Delhi, where they engaged not just with the community but with the clergy. And after 10 years of engagement, the Indian Divorce Act, which really came out of a campaign that the Christian women groups took upon themselves. So personal laws have undergone reform from the time of the Constitution to now. The greatest reform towards parity, equality one can see is under Hindu law, but that is not a surprise at all. Wherever the majority community is there, and that you can see, I'm sure there are people better placed than me to explain how this works, the minority-majority dynamics in any country. And therefore, laws relating to Hindu women have been repeatedly, either through the court or through the legislature, they have undergone reform. even for the Muslim community, including after the Shah Bano judgment and the law to reverse it, the model nikah nama, etc., that were brought about. So you see, or the triple talaq. Let us not forget for a minute that Muslim women went to court and asked for the change and for triple talaq to be repudiated and declared void. It is not the government. It is Muslim women. The case is called Shaira Bano. So obviously there is a lady called Shaira Bano who challenged it in the Supreme Court of India, and the court struck it down as arbitrary. So we have seen that women from within each community have at different junctures actually gone forward either through the legislature or through the courts to change the law. So you see piecemeal reform taking place. So it is not as though our personal laws and rights are frozen in time. There can be multiple approaches to getting a gender just, and as was again said, uniformity is not a virtue. It doesn't have any meaning actually. So the march towards equality and gender justice can be achieved through multiple routes. And one of the routes has been taking on cases either through court, etc. As was again, before I dive into Uttarakhand, as was again pointed out by Zoya, I think we should be very, very careful in saying you cannot, personal laws should not be tampered with. We should hold on to them. They are part of our cultural rights, our religious rights. We are beginning to hear a lot of that. And I think that should require some serious engagement. There are petitions filed by certain groups already in Uttarakhand saying no. The Muslim community can only be governed by Sharia law. The Muslim community again is very diverse. Zoya mentioned how Muslim women in the NRCCA protest came about. There are Muslim women's groups across this country who have repeatedly challenged the All India Muslim Personal Law Board and who want reform. So who do we even identify as the Muslim community will be something that we'll have to be very careful about, because many within the community also don't want to be governed by those kinds of laws which may have been made at a certain point of time in the world. Now coming to Uttarakhand, if you manage to wade through 392 sections and rules, which is a near impossible task, you will at the end of it ask yourselves, or at the beginning of it ask yourself one question: what new right, new benefit, new remedy does a woman get at the end of this law? And the answer is none. There is not a single new right that I get. You see, after all, you are saying after this law, women will have a better status in society. So then there must be something in the law which is going to give me either greater liberty or greater rights. One part of it, of course, is that, Muslim women get, there are 4 marriages allowed under Muslim personal law, and Muslim women, daughters, get half of what the Muslim son gets in inheritance. These are the 2 popular tropes that we are fed on. So yes, polygamy will not be permissible, it is prohibited, which I think, at least I don't see why one should be opposing something like that. I don't think most Muslim women are asking for a man to marry 3 other women. However, when it comes to the property issue, and I remember speaking last year on the same issue, that time the Uttarakhand law had not come into being. The Law Commission of 2018 also pointed this out. Under Muslim personal law, no person can will away by testamentary will but more than 1/3 of their property. So 2/3 of the property has to be distributed between the heirs. What does Hindu Succession Act allow? Anyone who is of Hindu origin can actually make a will and give the entire property to any one family member, 2 family members. You can give it to a third party. It is entirely your wish. Many of us here may belong to Hindu families, and we know that the will is used to actually ensure that girls, daughters do not get property. This is a common practice, and I have repeatedly requested students to please do research on this, because we don't have evidence and data. We all know from our personal experiences, we know from our extended family experiences. The will, as I call it, is the Brahmastra of the Hindu family to actually deny the Hindu woman all property rights. You can write everything in the code, equal, equal, equal. The Supreme Court will make you a co-partner. The will override everything, not ancestral property, but self-acquired property. And you will be left with nothing, some stuff given which will depreciate rapidly at the time of wedding is then supposed to be in lieu of your inheritance rights. That has not been altered. The 2018 Law Commission said if you are to change the law, model it on the Muslim personal law. Why do we not discuss this? Why do we not talk about this? Now let us go into what does the Uttarakhand Uniform Civil Code actually do? I have not seen in 30 years of practice a law that sets up such a strict regime of state inquiry, registration, inquiry, scrutiny, surveillance and reporting. There is absolutely no other law in this country which sets this up. And into what? Into your most private personal decisions. Who you will, even if you are marrying somebody, that marriage, forget the live-in, I'll come into the live-in in a moment. You have married, and you can marry under whichever ritual rites you want. There is no bar on that. Whichever form of marriage you wish to have under different religions. Every marriage will have to be registered. There is a portal. If you want to enter, there may be somebody who's an Uttarakhandi here. Because as was rightly pointed out, it doesn't matter, you can't run away from this law. It chases you wherever you go. So if you are an Uttarakhandi and you are married, you have to register on that portal. In order to register, you will find that when you will try to register, it will ask for your mobile number which is linked to your Aadhaar. The Supreme Court specifically in Puttaswamy said, you cannot ask for Aadhaar and mobile to be linked. You would remember, and if you go even today to buy a SIM card, every service provider from Airtel to Jio to whatever will say, give your Aadhaar. I at least would never give anybody an Aadhaar. The only place where we've been forced to link it is the PAN card. It is unconstitutional to ask you to link your mobile and Aadhaar. You cannot enter that portal without linking the mobile and Aadhaar. Once you will link it, you will then put your details of your marriage. After you have put the details, they will then hold a summary inquiry into it. You have got married. You may have gone to done a Arya Samaji wedding. You may have gone to a Maulvi and done a wedding. You may have gone to a church and done a wedding. After that, there will be an inquiry. Nobody has ever heard of this in this country. You are two adults in this country who have got married. And if you had that kind of wedding, it is very possible that your families, relatives are all involved in that. And it's not, you've not run away against the wishes of your family, blah, blah. They can at the end of that refuse to register your wedding. Why does the state have to? So the state will endorse an two adults' decision of the most private nature, who I wish to marry. Thereafter, after the registration, then there are various things that flow from it. Now, who is this person who is deciding? It's a sub-registrar, which in different areas will be different people. They will usually be a government official of an SDM level. You will then have to, if they don't register, you will be asked questions. You will have to satisfy them. It is one of the grounds on which they can refuse is morality or public policy. What is the morality if that wedding is permissible under religion? So one thing that does, because they do ask you for your caste information. when they asked you to register. Though I don't know why that is relevant. I mean, we do know why that is relevant. So one morality can be that your information will show that maybe you belong to different castes. And maybe that is seen as because it says public policy and morality, maybe it's a threat to what they call law and order in this country constantly. And they can refuse to register your marriage. So this level of intrusion into a private decision, you have the Supreme Court writing reams about privacy and saying this is your associational privacy, informational privacy, decisional autonomy, sexual autonomy. It all goes for a toss in this law. If you are, what is the age of marriage in this country? 18 for women and 21 for men. If the woman who is registering her marriage, I'm still on a religiously ordained marriage, and she goes in for registration, but she is 19, her parents will be informed that this person has come for registration of marriage. So what is it that the law is actually trying to do? The law actually has two very, very clear purposes. One, there will be absolute state control over your private decisions. And therefore, any attempts, because you see, they've been able to create a lot of hate amongst everyone in this country, and people are living in silos, they are ghettos, etc., etc. The problem is that young people still fall in love. That is a problem. You can't control it. It really is. And they meet everywhere and anywhere. This is going to ensure that there will be absolutely no transgression and no trespassing of the bounds of religion and caste. What is the second thing it does? The second thing is that it gives the state the authority. So what earlier you had to only battle family and elders and society and everybody telling you how to run your life, but now the state is backing that up. If, as was rightly said, so I may be posted as a CBI officer in Uttarakhand and this law will apply to me. It is actually bizarre and clearly unworkable. Supposing there is an Uttarakhandi couple, only one can be, even if one is Uttarakhandi, you have to register, and you are living in Delhi. So the person will then come forward. There is a separation that takes place. The woman wants to file for child custody or maintenance. So will she go to a Delhi court and ask for implementation of the Uttarakhand Civil Code? It makes no sense what is being tried out in terms of just the workability of it. Now let's come to the live-in couple. Now if you were to even dare to not marry and live together, then if you think this kind of surveillance and control of the state is intrusive, in that instance, your information will be immediately sent to the police station. The police is brought into a story where you are two adults living together. The police will be informed, there will be a summary inquiry, there can be a rejection. Now you are living together. Many people, I'm sure, are living even in Uttarakhand. I mean, young people do what they have to do. And then you don't apply. Like a young couple that I was representing there. On 27th February 2025 was the deadline that you had to give your statement of registration to the sub-registrar. If you don't give your statement, anyone can complain. Your neighbor, your distant uncle who doesn't like your friend, your disgruntled friend, anyone can actually file a complaint that this couple is living together without marrying and they have not registered the live-in. So you are actually creating a society where we are going to spy on each other, where we are going to then make each other's life hell by complaining. The registrar will then send you a notice that you have to apply, you have to give the statement for registration within 30 days. If you will not give the statement and still defy it, you will be put in jail, or there will be fine, or there will be both. Why is this happening? What is the harm the two people have caused to society? What is the state trying to do to us? Why do I think this law is more dangerous than most laws that I have ever read? Why should the state have this control over our lives? When I was before the Uttarakhand High Court, I was appearing in two petitions. One is a PIL filed by some of the most prominent women activists of Uttarakhand, who were part of the movement for the creation of Uttarakhand state. They've taught there for years, etc. So these are people who are really rooted and have fought for the people of Uttarakhand. And the other is for a live-in couple. What is this law, and what is the kind of approach the state had, the court had? So the judge before whom I appeared, he was curious. He said, but what is wrong? If a live-in relationship breaks up, the woman usually has a bad time. So it is good if they register. Little bit of regulation is good. So this is how mostly people are thinking of it. Ki bura kya hai? Now the problem is in how you start the question. When did it become part of the state's job to decide what is happening between two people, except when there is harm? So if there is domestic violence, the state must do something. If there is desertion and destitution, the state must do something. Some of the things that Zoya said right in the end are very, very important as to what are the criteria or the reasons, factors on which the Muslim community is still marginalized. Who can actually rectify those factors? Whether it is education, employment, political representation, etc. The only authority which can rectify that is the state. What are the steps and measures the state is taking to help Muslim community, to help the Muslim women community? What are the steps and measures? Is there any scheme that anybody has heard of over here? None of that is going to be done. What is going to happen is that the state is now going to have a stranglehold over our lives so that there is absolute, we are going to live as just in our caste, religious communities. In live-in couples, the next question the court posed to me was, but what about the child? You don't want any child to be a bastard. So I said, actually, this law says every child born out of a relationship, live-in or marriage, will be considered a legitimate child. It's section 379 of the UCC Act. So there is no question of anybody being an illegitimate child. There are many judgments of the Supreme Court that no child will ever be considered illegitimate and all children will have rights. So that part is taken care of. But who will look at? The man will run away. So one thing it asks, if the live-in relationship is breaking, then you have to again inform. Then you have to give a statement of termination. Then that will have to go to the police station immediately and to the district superintendent of police. And they can ask the police to take appropriate action. We don't know what appropriate action is because it's not defined in the law. So if you want to live together, they will first decide. If you want to break the relationship, again they will have to be informed. And when you terminate the relationship, the woman will have to put on the portal, is she pregnant or not? Why do they want to know? So we are told, oh come on, what if the child is born? Who will look after the child? The law has provision, no, for maintenance. The domestic violence law recognizes live-in relationships since 2005. Women in live-in relationships have a right to maintenance, for children. This is not a discovery we are making in 2025. These are just things which are popularly sold and everybody's like, yes, 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 the woman will be better off. But women have those rights already. And those rights are also given here. Why should I put my pregnancy information, which is then going to go to the local thana? What kind of a world are we trying to create that the local constable should know whether I'm pregnant or not? Is this the privacy women are allowed? I was so furious after reading this. I was saying, why don't they tell all women to start putting their menstrual cycles over there and they can keep tabs if we are pregnant or not? I mean, what is this country have? What is going on? we really have to be alert to what the state is doing to us today. The state is changing the equation between the state and citizen, and every shot is being fired from the shoulders of women now. And women will have to stand up and resist this. And a live-in couple's life is going to be hell, because everybody is going to can come up and file a complaint, can ask you questions, although they may be, then there is the landlord. There is always the landlord, as young people well know. If you are a live-in couple, the landlord will have to give multiple details of himself. Which landlord is going to allow a live-in couple to live in a rented house, and it's not just tenant verification which has to happen everywhere in the country. It is multiple other details. You will also have to tell any prior relationships which have been terminated. So it's like literally giving your entire personal history, which you may not have even shared with many of your close friends, will then have to be put out there. But you don't get anything at the end of the day. However, if you don't do all this registration, and now please try and imagine, the working class of Uttarakhand is going to be able to put all this onto a portal. Then they have third parties who will then run these little kiosks where people have to pay money to put your data, and that data is going to the third party also. If you do not do it in a certain period of time, government benefits, government schemes, government services can be denied to you. So can I be denied rations? Can I be denied Narega employment? What is the purpose of this kind of law? This is a draconian legislation, and it must be understood and it must be opposed, but not on the ground that every religious community must be allowed to hang on to slightly archaic, now obscure religious practices. I'll stop there.